judiciary's obligation to provide equal justice to the poor is a constitutional imperative. I regard the judiciary's obligation to provide equal access to that equal justice as no less important.
He treasured the rule of law. He thought it was a sacred obligation of the court to do the very best it could. When our opinions were circulated, he would allow for unlimited discussion because he wanted to make sure that every opinion that came out of this court was the best it could possibly be.
He sought to establish a court culture that was responsive to the current needs of the evolving society. He streamlined policies and practices that guaranteed access to the courts by all people as part of his broad concept of equality.
He was completely, to his core, committed to racial, ethnic, and gender justice.
I first became aware of Chief Justice Wilentz when Judge Marilyn Loftus wrote him a letter asking for the appointment of a small committee to help her collect some data. And he didn't say, let's have a little committee to decide whether there is gender bias in the courts. He just came right out and he said, we're going to have the New Jersey Supreme Court Task Force on Women in the Courts to investigate the extent of gender bias in the New Jersey court system and take action to eliminate it. The task force was appointed with a one-year mandate to develop information for the 1983 Judicial College. And Chief Justice Wilentz introduced us, and as soon as he was finished speaking, several of the male judges in the audience got up very ostentatiously and started to walk out. And he said very loudly, "Sit down, you need it the most." And then at the end of our presentation, he made a statement which became the quotation of the day in the New York Times. He said, "There's no room for gender bias in our system. There's no room for the funny joke and the not so funny joke. There's no room for conscious, inadvertent, sophisticated, clumsy, or any other kind of gender bias, and certainly no room for gender bias that affects substantive rights."
When he became Chief Justice in August of 1979, he became head of a monochromatic judiciary. He made changing the face of the judiciary in New Jersey one of his top priorities.
This is a momentous day in the history of our judiciary. Young children on our playgrounds, little kids starting school, adolescents just growing up, will see a bright ray of hope that they didn't see before. Everyone should celebrate this day, for it is a good day for all of us. It is a good day for society.
Abbott v. Burke, too, was a landmark decision. No one can read that opinion without being impressed by the depth of Chief Justice Wilentz's belief and commitment that what the court was doing was right.
Public education shouldn't depend on where you live. Shouldn't depend on whether you're rich or poor. Our predecessors in Robinson v. Cahill were the court that decided that the thorough and efficient clause was enforceable, that where there is an inequality of funding, absent some kind of showing on the record, we will assume that the mere inequality of funding means that the kids who get less aren't getting a thorough and efficient education. We didn't make that up. That started somewhere else. And me, I don't do it. There are 7 of us of all different kinds of points of view. So what we found before us was a record where the inequality of funding not only had continued, but the consequences of the inequality were demonstrated, and that the only way to achieve the constitutional requirement, as we understood it from our predecessors, was to do what we did.
We spent a lot of time in disagreement because the issues that came before us were issues about which people could and would disagree. Nevertheless, it was just a very professional court with a wonderful atmosphere and an absolutely great leader.
I was especially struck by his humility. his willingness always to listen to other points of view and to learn.
He had a deep, heartfelt, warm concern for people who were disadvantaged. He understood the needs of the working poor and what justice meant to them.
The Mount Laurel case perhaps was even more controversial than the Abbott v. Burke case. The Supreme Court in Mount Laurel I held that it was a constitutional requirement for municipalities to provide housing for low and moderate income families as part of their zoning ordinance. But Mount Laurel I was mostly ignored, and so a second Mount Laurel case was filed, Mount Laurel II. Chief Justice Wilentz wrote a prodigious opinion of some 250 pages, in which he provided a way to force municipalities to accommodate that housing. It was called the Builder's Remedy.
In 1987, he was able to persuade the Supreme Court of New Jersey to adopt the interest on attorneys' trust accounts, named as IALTA, as a method of funding legal service in New Jersey.
The early years of his Supreme Court tenure were the most dangerous and challenging years in legal services history. We were suddenly, as a federally funded program, threatened with complete extermination. And we began a progress over a couple of years of moving from solely federal funding to state-funded program. His support during this period gave us a sense of confidence that we were going to survive. It gave us also credibility that this was a program that really mattered and that New Jersey needed to get behind. It made all the difference for us during the most challenging time that we had.
When I became Chief Justice, we pulled from the file cabinet a number of files, including speeches he'd made for legal services and about legal services. What I learned from Chief Justice Wilentz after he died was the love he had for the organization, the concern he had about its viability, about the resistance to funding, about the important work that legal services was doing.
I have discouraged judges from doing what I am doing right now, namely speaking before special interest groups. And I have discouraged them for obvious reasons, all related to the importance of judicial impartiality in fact and in appearance. We do not want the public to wonder or worry if the judge or the judiciary favors some special interest or some controversial issue associated with that interest. The judiciary should conduct itself in a way that reinforces the public's confidence in our impartiality. Legal Services of New Jersey is such a special interest group, clearly associated with controversial causes. But for the judiciary, it is much more than that. Its mission transcends its special interest as advocate for the poor. Its mission transcends the sometimes controversial causes it supports. Its mission is access to the courts, access to justice, equal justice, justice for all. Its mission is to see to it that the courthouse doors are just as open for the poor as for the rich. A judiciary that doesn't support that mission has forgotten its own mission.
Although the chief died on July 23rd, 1996, my memories of him and legal services memories of him will last forever. He did indeed leave his footprints on the sands of time.
There is a long road to travel from equal justice for all to equal access for all. But that is the road we are on, and I hope we won't get off until we get there, no matter how long it takes. Thank you.